Does a one-time workman's comp lump sum disqualify you if you're on Medicaid? I understand it will be considered as income for the particular month and you'll be disqualified, but what about the next? So if I'm tracking with this, it's sounding like you're thinking that this lump sum payment that comes in would be counted as income for 1 month, but could potentially not be counted against you for Medicaid purposes moving forward. So most likely a lump sum payment, which is unearned income, wouldn't be counted against you as income for Medicaid, but the one time payment definitely could end up affecting your assets depending on what you do with it. So you get this one time lump sum. Depending on what the amount is, if there's things that you actually legitimately need to purchase that don't fall under any kind of penalty period, like you're not giving money away, but you actually have legitimate expenses that Medicaid allows you to pay and it eats up this lump sum, then obviously you can pay those things and continue qualifying for Medicaid. However, if that's not the case, let's say you're receiving a large amount of money and you need to be able to do something with it, because what's going to eventually happen is if you take that lump sum and put it in your bank account and it puts you over the current asset limit of $2,000 a month after you pay any kind of legitimate expenses from it. If you're over that $2,000, well, then you are going to run into issues with your Medicaid eligibility. So your options in that scenario, well, a lot of attorneys will go to a special needs trust as the first option, meaning you can actually receive the lump sum settlement payment into a first party special needs trust. It's called first party because it is actually money that you're receiving. It's not money that someone else is putting in trust for you. But the special needs trust can allow you to have that lump sum deposited into the special needs trust bank account, and it can be used throughout your lifetime in accordance with the rules that are set up under the trust. However, any funds that are available in a first party special needs trust after you pass away are subject to being reclaimed by Medicaid for them to get back some of what they paid for you. So maybe that's not always the best option for everyone. There's other options depending on your particular scenario. One could be a pooled trust, or however, with a pooled trust, again, money that's not used goes to Medicaid. If you have a close family member or a close friend who's providing care for you, you could potentially enter into a personal care contract with that individual. And depending on your age, because the contract follows your estimated length of time that you're going to be living, you can pay them a certain amount. They can receive that in a lump sum. Under certain circumstances, though, under most circumstances, they do have to treat that as income themselves, so there is some taxation there. However, the point I'm making is there's multiple ways that this money that you receive can potentially be moved to a location where it's not going to affect your Medicaid eligibility. Now, Medicaid does always want changes in assets or income to be reported, and that is a typical requirement for Medicaid, that some change occurs that you do need to report it. But that doesn't mean that you're not permitted to rectify it so that it destroys your benefits or moving forward disqualifies you. And which way you want to do that, or what you want to do with the funds, is going to be very dependent on your particular circumstance. So that's why you would need to speak with an elder law attorney. This would be something, especially depending on the amount of money that you may be getting. It would be very, very wise to speak to an elder law attorney because, especially here in Florida, you have several options, and your unique circumstance and the type of Medicaid benefits you're receiving is going to play a role into which one you should choose. Another thing I should mention here, though, because you do bring up it being counted as income. So I have seen structured settlements where money is paid monthly to the individual, and it's actually done in a way so that they don't go over the income limit, because when you structure them that way, then you're getting these monthly distributions, then it is going to be looked at as income rather than an asset, depending on the amount and how long, a period you think you'll be able to stretch it out, again, based on life expectancy. That could be an option or something to look at as well, because if you're able to stretch out those payments but still not go over the income, or if you're only going over the income by a small amount, you could always set up a qualified income trust or Miller trust that could also make sure you don't lose your benefits because you're over the income amount. But again, the important thing here is there's lots of options. There's lots of options of how to fix it so an asset isn't going to put you over the limit. And there's also options when it's considered income. Again, though, the lump sum settlement, in most cases, that's going to be considered an asset if it still remains in your bank account for a month and it pushes you over that $2,000 asset. Meaning if you're just taking in that settlement payment, you're putting the check in the bank and you're doing nothing else with it, that turns it into an asset. And you better find something to do with that, so that you have that bank account balance down to $2,000 for at least a day out of the month, or you're going to risk disqualification of your benefits until that money's gone, which you obviously don't want to do. But the point is you have lots of options. So the right thing to do is to talk to an elder law attorney in your area to find out what's best for you. And if you're in Florida, we would love to talk to you here. We're at Cause Law Office, and the link is in my bio.